A court in Lokoja just undid a ruling it made 6 months ago, and in doing so, it may have decided who gets to run for president of Nigeria in 2027. On June 26th, Justice Issa Dashen of the Federal High Court set aside his own December 2025 judgment, the one that had ordered INEC to register the Nigeria Democratic Congress, the NDC, the party Peter Obi joined to make his second run at the presidency. The official reason is narrow and procedural. A group called the Peace Movement Party says its logo was used without permission, and it says it was never given a chance to be heard. But here's the question nobody arguing on social media is actually answering. If this is really just about a logo, why has it triggered a national fight over whether Nigeria is sliding toward a one-party state? That's what we're getting into today. Before we go any further, if you are new to this channel, welcome. Naija Insight Desk exists for one reason: to give you the kind of analysis that goes beyond the headlines and the noise. Subscribe now because this conversation is about to get deeper. Let's establish exactly what happened, because a lot of what's circulating online has already blurred the timeline. Go back to December 10th, 2025. The Federal High Court in Lokoja ordered INEC to register the Nigeria Democratic Congress, the NDC, as a political party after INEC had refused. That order gave the NDC legal existence. 4 months later, in early 2026, Peter Obi left the Labour Party and joined the NDC with Rabiu Kwankwaso as his running mate, positioning it as his vehicle for the 2027 presidential race. Then, on Friday, June 26, 2026, everything reversed. A group calling itself the Peace Movement Party went before the same court and argued that the logo the NDC used to register, the victory sign, actually belonged to them and that they were never made a party to the original case. Justice Dashen agreed. He ruled that leaving the Peace Movement Party out of the original proceeding was a constitutional defect serious enough to void the entire judgment. His order restored the status quo to what it was before December 10th, before the NDC had any court-ordered registration at all, and directed that the case be reheard, this time with everyone at the table. Two things about the timing matter. First, this didn't happen in isolation. Just 11 days earlier, on June 15th, a different Federal High Court judge in Abuja had ordered INEC to deregister 5 smaller parties: the ADC, Accord, Action People's Party, Action Alliance, and Zenith Labour Party, for failing to meet the constitutional performance threshold. Second, INEC itself says it hadn't even received the certified copy of the Lokoja judgment when the reactions started pouring in, meaning most of the loudest voices in this fight were responding to media reports, not the written ruling. Is this a new development or a recurring pattern with a new face? On the surface, court decisions voiding party registrations aren't new in Nigeria. What's new is the timing, 14 months before a presidential election, against the party carrying the most visible opposition challenger. Here's the detail most coverage buried. The court did not expressly order the NDC deregistered. It set aside the order that created it. NDC's own leadership has hung on to that distinction all week, insisting there is no legal basis for panic. Keep that distinction in your head because it's going to matter a lot more in the next section than the headlines suggest. 3 institutions sit at the center of this: the Federal High Court, INEC, and indirectly the Court of Appeal that now has to sort out what happens next. Start with the judiciary. The legal question at the heart of this case is about joinder, whether a party with a direct interest in a case has to be included before a court can rule. Justice Dashen's position is that the Peace Movement Party had a real stake in the logo dispute and was left out, so the earlier judgment is void, not just wrong. Senior lawyers have pushed back hard on procedural grounds, arguing that once a court delivers a final judgment, it becomes what Nigerian law calls functus officio, it has done its job and has no power to revisit that same judgment through a fresh motion. If that argument holds at the Court of Appeal, this entire ruling could collapse on a technicality that has nothing to do with Peter Obi, the NDC, or 2027 at all. Now, INEC. The Commission's public posture has been almost entirely procedural. It says it's waiting for the certified copy of the judgment before deciding anything, and in the meantime, it has reportedly given the NDC access to its candidate portal to continue uploading names, including Peter Obi's. That's a striking detail, an electoral commission being simultaneously accused of colluding to erase a party from the ballot while operationally still letting that party upload its presidential candidate. Where does legitimate institutional caution end and political calculation begin? That's genuinely contested right now, and anyone telling you they know for certain is guessing. And there's one more institutional actor almost nobody is talking about, the man who first raised the alarm about the NDC's registration process months before any of this became a national story. We'll come back to him, because his account complicates the judicial coup narrative in a way both sides would rather you didn't examine too closely. Has this institution functioned as designed, or has it been captured? Nigeria's judiciary has, in recent years, delivered rulings that cut against sitting power. This is the same court system that upheld disputed presidential election outcomes on technical evidentiary grounds in 2023, drawing criticism from Obi's camp back then, too. That history doesn't prove this ruling is either legitimate or captured. It proves that both trust and distrust in these institutions are already deeply seated, which is exactly the terrain any political actor on any side benefits from exploiting right now.
Let's talk about who actually gains and who actually loses here, because that's where the real analysis lives, not in the legal footnotes. Start with who benefits from delay and uncertainty. Every week the NDC spends fighting for its legal footing is a week it isn't spending building structures, running ads, or locking in state-level alliances. INEC has already fixed August 19, 2026 for the start of presidential campaigns, with the presidential election set for January 16, 2027. That's not a lot of runway. If the Court of Appeal takes months to resolve this, the NDC enters campaign season still explaining its legal status instead of making its case to voters. A real cost, independent of who's right on the law. Who loses influence? Ironically, it may not just be Obi. NDC's national chairman argues that the party's rapid growth, he says it became a major opposition force within 4 months of registration, is precisely what unsettled the ruling party. That's the party's own framing, and you should treat it as a claim, not a fact. But it points to something real. Any ruling that weakens NDC's footing removes a competitor from a crowded opposition field that already includes the PDP, the ADC, and Atiku Abubakar's camp, all jostling for the anti-APC vote in 2027. Now, the APC's position. Senior APC officials, National Chairman Nentawe Yilwada, National Secretary Ajibola Bashiru, and National Publicity Secretary Felix Morka have consistently and directly denied any role in the legal troubles facing opposition parties, insisting the challenges are self-inflicted, rooted in internal divisions rather than external interference. That denial matters. It's the clearest on-record APC response to the collusion allegations, and any honest analysis has to include it alongside the accusations. What does this signal about 2027 positioning? Two competing stories are being told in real time. The opposition story. This is one entry in a pattern. The June 15th deregistration of 5 smaller parties, now this, that adds up to a coordinated squeeze on anyone who could challenge the APC. Atiku Abubakar has explicitly called it evidence of a push towards what he termed a one-party system. The NDC's House of Representatives caucus went further, calling it a judicial coup against democracy. The government story, these are separate, procedurally distinct court cases, one about a constitutional performance threshold, one about a logo dispute and joinder, being lumped together after the fact into a narrative of persecution. Both of those stories can't fully be true at the same time, so which one survives contact with the actual legal mechanics? That's what the next section is built to test. Who's conspicuously silent? Notably, President Tinubu himself has made no direct public statement on this specific ruling. The response has come through APC party officials, not the presidency. That silence is itself a signal. It lets surrogates absorb the political heat while keeping the president above the specific legal fight, whatever the reason for that choice actually is. Now, if what you just heard challenges what you thought you knew, drop it in the comments. I want to hear your read on this before we get to the part that reframes everything. Step back from the personalities for a moment. What does this actually mean for the country? On the federal-state power balance, this is a fight happening entirely within federal institutions, a federal court, a federal electoral commission, with state governments as bystanders for now. But if opposition-aligned governors start reading this as a signal about how the center will treat dissent, that could shape alliance behavior well before campaign season formally opens. Economically, the direct impact is limited. This is not a monetary policy story. But investors and ratings agencies do watch democratic institution stability as a proxy for broader governance risk, and a prolonged high-profile fight over whether a major opposition candidate can appear on the ballot is exactly the kind of headline that gets cited in country risk assessments, even if the underlying legal dispute is narrow. On security, so far, every faction involved, NDC leadership, the obedient movement, opposition parties, has explicitly called for calm and for the legal process to run its course rather than for street mobilization. That restraint matters and deserves to be reported, not just the heated rhetoric. The bigger security risk isn't imminent, it is slower erosion. If enough Nigerians conclude that legal electoral routes to change don't work, that belief itself becomes a long-term stability problem, regardless of who's right in this specific case. Does this deepen or ease existing regional tensions? To its credit, this dispute hasn't broken down along ethnic or religious lines the way some past Nigerian political fights have. The arguments so far are institutional and partisan, not communal. That's worth naming plainly, because it means the us versus them energy here is opposition versus government, not one region or faith group against another. And for Nigerians below the poverty line, the people furthest from all of this, a stalled or contested opposition candidacy doesn't fill a single pothole or lower the price of Gary, but it does shape whether the 2027 ballot offers a genuinely competitive choice, which is the mechanism, however indirect, through which economic grievances eventually get addressed or ignored. Zoom out to how this reads beyond Nigeria's borders. Regionally, ECOWAS has had a rough few years managing coups and constitutional crises in Mali, Niger, Burkina Faso, and Guinea. A drawn-out legal fight over whether a leading opposition figure can be on Nigeria's presidential ballot doesn't rise to that level, but West African democracy watchers are primed after that run of coups to read any ambiguity around electoral access in the region's largest democracy as a signal about the health of civilian rule generally. For the diaspora, in the UK, the US, Canada, South Africa, the practical thing to understand is this: nothing here currently prevents diaspora Nigerians from continuing to organize or donate to any party's campaign. What's actually uncertain is which party structure they'll be organizing around by the time campaigns formally open in August. And does this connect to a broader global pattern? It's part of a wider story analysts have been tracking across multiple democracies, courts and electoral bodies becoming the terrain where power struggles get fought instead of the ballot box. Nigeria isn't unique in that regard. What makes this case worth watching is simply the scale. Africa's most populous country, its largest economy, and a presidential race that's genuinely competitive rather than pre-decided.
Let's steelman the other side before picking this apart further, because the strongest case for the ruling being ordinary and defensible deserves to be heard in full. The strongest case for the ruling being ordinary and defensible is, courts overturn their own judgments on procedural grounds all the time when a genuinely affected party wasn't heard. That's not exotic, it's basic due process. The Peace Movement Party's underlying claim that its logo was used without consent hasn't been disproven. It simply hasn't been tested yet because the case is being sent back for a full hearing with everyone included. On that reading, this isn't persecution. It's a court correcting a shortcut it took the first time. Remember the man who raised the allow early? A promoter of a separate association, the ADA, has said publicly that he flagged concerns about the NDC's registration on national television the day after INEC's original announcement. arguing he recognized irregularities in the process before any of this became politically charged. He's since called Justice Dashain's reversal an honorable act. Whether or not you find his account persuasive, it matters for one reason. It means the seed of this legal challenge predates Obi's decision to join the party and predates the current political framing. That doesn't settle who's right, but it's a fact that complicates a simple "this was engineered to stop Obi" narrative, and a fair analysis has to sit with that discomfort rather than skip past it. The most common misconception online is the claim that the court deregistered the NDC outright. It didn't. Multiple legal correspondents and INEC itself have been explicit that the ruling set aside a prior judgment and ordered the underlying case reheard, not that it cancelled the party's existence. If you've seen headlines using deregistered as a settled fact, treat them skeptically. The nuance being lost in the noise. This can simultaneously be true, a legally defensible procedural ruling, and politically convenient for a government that benefits from a weaker opposition field. Those two things are not mutually exclusive, and pretending they are is how both "it's just the law" and "it's obviously a coup" become oversimplifications. So, what does this mean specifically for Nigeria's democratic trajectory and ordinary citizens? It means the next few months of Court of Appeal proceedings will tell us more about the strength of Nigeria's judicial institutions than any single statement from Obi, the APC, or INEC possibly could. Here's where the analysis pays off. 3 likely next moves. First, the Court of Appeal in Lokoja will have to rule on the NDC's appeal, and legal observers are already flagging the jurisdiction question as its likely first battleground, meaning the case could be decided on that technical point before anyone even reaches the merits of the logo dispute. Second, expect INEC to keep threading a careful middle path, continuing to process the NDC's candidate uploads administratively while publicly declining to take a substantive position until it has the certified judgment in hand. Third, expect opposition parties, NDC, PDP's Turaki faction, the ADC, and civil society voices to keep linking this case rhetorically to the earlier deregistration of the 5 smaller parties, whether or not the Court of Appeal treats them as legally connected. Signals to watch for in the coming weeks: whether the Court of Appeal sets an expedited hearing date, given the compressed election calendar, whether INEC issues any formal statement once it receives the certified judgment, and whether any of this affects the August 19th start of presidential campaigning. Under what conditions does this escalate? If the Court of Appeal takes an unusually long time, or if INEC's practical posture towards NDC's candidates shifts from cautious accommodation to obstruction, expect the one-party state framing to harden from a talking point into a genuine mobilizing narrative. Under what conditions does it de-escalate? A reasonably fast, well-reasoned Court of Appeal ruling in either direction that engages seriously with the jurisdiction question would do a lot to diffuse this, simply by giving both sides a legal answer to argue over instead of a political vacuum to fill with speculation. 12-month outlook. This resolves one way or another well before the January 2027 election. Nigerian courts have moved faster than this on time-sensitive electoral matters. 3-year outlook. Regardless of how this specific case lands, it adds one more data point to a longer argument Nigerians are having about whether their courts are a reliable referee for political competition, and that argument will outlast this particular ruling by a long way. So, let's return to where we started. The real question wasn't whether a logo dispute is legally valid. It almost certainly is on its own narrow terms. The real question was, why has a procedural ruling about joinder become a referendum on whether Nigeria's institutions can be trusted to referee its own democracy? The honest answer, based on everything we've walked through, is that it's become that because trust in those institutions was already thin before this case ever reached a courtroom. Thin enough that a technical ruling about a logo could plausibly be read by reasonable people as either routine due process or as one more brick in a wall being built against competitive politics. Both readings are currently defensible. Neither is currently proven. I'm not going to hand you a prediction dressed up in certainty. What I'll say is this: watch the Court of Appeal, not the press statements. The statements are strategy. The ruling is the fact. Push back on this analysis if you think I've missed something. Genuinely, I want the correction in the comments. And here's the thread I'm leaving open. That ADA promoter who says he raised the alarm months before any of this became political, if his account holds up under scrutiny, it changes how we should read everything that followed. We're digging into that next. If this analysis gave you clarity, not agreement, clarity, share it with one person who needs to understand what is actually happening. Like, subscribe, and I will see you in the next one.